Okay. Good morning, Chairman Pierce and distinguished members of the board. My name is Kirschner. I'm a partner with Jones Day. I'm testifying this morning on behalf of the American Hospital Association and two of its affiliated personal membership groups, the American Society of Healthcare Human Resource Association and the American Organization of Nurse Executives. With me today is Carla Luggiero of the AHA. Thank you for the opportunity to speak this morning about the requirements for a written statement of position contained in the board's notice of proposed rulemaking. A more thorough discussion of the AHA's arguments with respect to the NPRM is included in the written comments submitted earlier this week to the board. Drawing on the experience of its member hospitals that are routinely involved in NLRB elections, the AHA believes that the NPRM's proposed requirements that a statement of position, including various employee lists that accompany that, to be submitted within 7 days of a petition being filed or risk waiver of any sort of number of issues is inconsistent with the Act and it's unreasonable in the real world and in fact could backfire, resulting in further delays in the process of getting parties to a representative status. In our view, this is one of several examples in the NPRM where the board appears to be sacrificing a fair process to achieve the goal of faster elections. This is an imbalanced position in our view in light of the congressional mandate to hold an appropriate hearing under Section 9C, but it also presents a substantial risk that more representation hearings will actually be held under the proposed scheme than under the current scheme. And therefore that actual bargaining relationships will be delayed as a result. The current rules result in stipulations without a hearing in over 90% of all petitions being filed. The NPRM proposes significant rule changes to virtually every aspect of the representation process. And the net result of all of these overlapping changes happening at the same time is impossible to predict. And it's easy to see that the confluence of all of these different changes occurring at once would result in more petitions going to hearing and more delays in the process. The NPRM proposes a requirement that the non-petitioning party, which is almost nearly always the employer, shall state several things, including a description of the most similar unit that the employer concedes is appropriate if the petitioned unit isn't deemed appropriate. Also, identifying any individuals occupying classifications which the employer intends to contest, along with the basis for that contention, and a description of all other issues that the employer intends to raise at the hearing. Along with the statement of position, the employer must produce both the requested list of the petition, as well as, if the employer contends that the unit is not appropriate, another list of the employees who would fit within the appropriate unit. The penalties for failure to comply with these numerous requirements are significant. If the employer fails to furnish the employee list with the standard of position in a timely manner, the employer shall be precluded from contesting the eligibility or inclusion of any individuals at the pre-election hearing, including by presenting evidence or argument or by cross-examination of witnesses. In addition, the NPRM includes a preclusion penalty regarding evidence or argument for any issue that the party failed to include in the statement of position. The board's proposal to preclude employers from raising issues of unit appropriateness as a penalty for failing to provide an employee list in the expedited manner is particularly troublesome. Many of the board's standards for determining unit eligibility and supervisory status are fact-intensive and time-consuming. Many of these cases arise in the hospital sector, and the AHA's members have great experience going through the fact-intensive, time-consuming process of determining whether any particular set of employees, such as charge nurses, are or are not supervisors under the board's current standards. In addition, hospital bargaining units are oftentimes quite large given the existing acute care rules. And having employer hospitals trying to determine who is, for example, a technical employee under the board standards rather than a service employee can be a very time-consuming process, and it will take some time to go through large units and determine who's in which unit and who's not, and the penalty for getting that wrong is significant under the proposed rules. The proposed statement of position would require interested parties to articulate fixed position with respect to the scope of the putative unit prior to the introduction of any evidence. That, we believe, is unfair and unrealistic in the real world, given that the hospital's HR systems are not set up to align with the board's current rules for bargaining units. In fact, this could have an unintended consequence of prompting fewer election agreements and more contested hearings, because during the timeline before the hearing, whether that's 7 days or even longer, employers will be focused instead on providing and preparing the statement of position and the employees list, thereby taking the time away from trying to negotiate the stipulations that currently exist in 90 and are reached in 90% of cases. So by having this obligation, which we think is onerous, the risk is that employers will be focused on putting together everything they can in the statement of position. They'll be treating it like an answer in civil litigation, putting every defense they can think of or risk waiver, and thereby using all the time to focus on that rather than actually trying to reach an agreement with the union about what an appropriate unit is. Thank you.
Do you think that it is, let me raise specifically with respect to the proposed rules requirement that the employer identify a similar, most similar unit, that the employer should, that it helps the process of either stipulation or the process of hearing, that the employer actually take a position on the unit that's petitioned for?
Speaking on behalf of the American Hospital Association, where we have prescribed unit rules, in my experience, I think it is commonplace for hospital employers to identify whether the petition for classifications are those that fit within a service unit or in a technical unit or some other RN unit, for example. And oftentimes, it should be incumbent on the union to identify which of those prescribed units they are seeking to represent.
Right, presumably that's in the petition, but I'm just asking, should the employer, does it help the stip or the hearing for the employer to take a position on what it believes the unit should be?
I would also assume that the prescribed unit would be somewhere within the petition. Sometimes it's not. Sometimes they actually do just list classifications that they believe comprise the prescribed unit. So it is helpful still to get further information from the union. At the time of the hearing, and once the evidence is known about what the union is seeking, then I think it is appropriate for the employer to articulate a position with respect to what the appropriate unit would be under the acute care rules, because they are prescribed.
But not during the stipulation discussions or at the beginning of the hearing? In
my experience, given that virtually all petitions result in stipulations, you do have that discussion with opposing counsel during that timeline leading up to the hearing. I mean, you couldn't reach a stipulation in an acute care petition unless you are putting out there what you think the appropriate unit would be.
Yeah.
So I think that during that process, it's commonplace under the current rules for the parties to talk in advance of the hearing about what the appropriate unit would be.
Okay. I don't think I got an answer to the question.
Well,
but
my
question was, should the employer take a position during before the start of the hearing, during stip discussions, and at the beginning of the hearing?
I believe that taking a position would be appropriate if the employer has been given sufficient information from the union with respect to what unit or units they are seeking to represent.
Okay.
Thank you. That's the technical legal proposition. What's sauce for the goose is sauce for the gander. Is that right?
Correct. Right.
Here's the one question I have, and I'll be brief. Have you encountered any situations where you understood going into the hearing that a particular healthcare facility had classifications that operate one way, and where in the course of the hearing you discover that the various job classifications actually interact in some different way?
Sure. There are several examples, particularly in the trying to determine whether employees are service employees or technical employees. You can have employees who work in a lab, for example, and whether sometimes they do phlebotomy, and phlebotomy would typically be seen as a service position. However, they may have additional duties on top of that that may or may not be reflected in their job description, which would put them in the technical classification. So the board has these prescribed rules, but there are positions that are on the bubble and go either way depending on how the hospital actually uses them. So it is not a easy answer for hospitals, particularly when faced with large bargaining units, to determine who are the people who are within one unit or the other. And it takes sometimes evidence being put on at a hearing. And sometimes, the union has it wrong as well because they misunderstood what people are doing.
Thank you.
Thank you.
Just one question for Mr. Kirschner, based not so much as a representative of the American Hospital Association, but as a very experienced practitioner. Wouldn't most of the information that's called for in the proposed statement of position be information that you would ascertain as a matter of course in preparing for the hearing?
Yes, you should. And it depends on how much time you have before the hearing, which then intersects with some of the other proposed rules about whether it's 7 days as a hard deadline. But I think that many of those topics are relevant to preparing for the hearing. Many of those topics are also relevant to negotiating the stipulation, which I think should be the emphasis during that time leading up to the hearing. And my concern is that by having extensive obligations imposed on the employer, requiring them to provide answers in every possible issue that you could potentially raise during a hearing, that the attention is going to be off the ball of trying to reach a stipulation. Instead, you're just going to be preparing a statement of position with the attendant employee list that are going to ensure that you're not inadvertently waiving anything. So I think that is one of the real concerns. The statement of position coupled with the waiver issue makes this proposal particularly concerning.
Thank you.
Okay, thank you very much.